the supreme legislative body of the Republic of India. It is a bicameral legislature composed of the Rajya Sabha, Council of States, and the Lok Sabha, House of the People. The Lok Sabha is the lower house of parliament. It has 543 members, who are directly elected by the people of India using a first-past-the-post system. The term of the Lok Sabha is 5 years. The Rajya Sabha is the upper house of parliament. It has 245 members, who are indirectly elected by the members of the state legislative assemblies and the Union Territories legislative assemblies. The term of a Rajya Sabha member is 6 years, and one-third of the members retire every 2 years. The Parliament of India is responsible for making laws, approving the budget, and overseeing the work of the government. It also has the power to impeach the President of India and to remove the Prime Minister and other ministers from office. The current Lok Sabha was elected in 2019 and is scheduled to dissolve in 2024. The current Rajya Sabha was elected in 2020 and is scheduled to dissolve in 2026. The number of Rajya Sabha seats for each state is determined by the population of the state. Madhya Pradesh has 11 Rajya Sabha seats. Here is a table of the number of Lok Sabha and Rajya Sabha seats for each state. State, Lok Sabha seats, Rajya Sabha seats. Andhra Pradesh, 25, 11. Assam, 14, 7. Bihar, 40, 16. Chhattisgarh, 11, 5. Goa, 2, 1. Gujarat, 26, 11. Haryana, 10, 5. Himachal Pradesh, 4, 3. Jammu and Kashmir, 5, 2. Jharkhand, 14, 6. Karnataka, 28, 12. Kerala, 20, 9. Madhya Pradesh, 29, 11. Maharashtra, 48, 19. Manipur, 2, 1. Meghalaya, 2, 1. Mizoram, 1, 1. Nagaland, 1, 1. Orissa, 21, 9. Punjab, 13, 7. Rajasthan, 25, 10. Sikkim, 1, 1. Tamil Nadu, 39, 18. Telangana, 17, 7. Tripura, 2, 1. Uttar Pradesh, 80, 31. Uttarakhand, 5, 3. West Bengal, 42, 16. The Parliament of India meets in the Sansad Bhavan in New Delhi. The Sansad Bhavan is a white marble building that was designed by the architect, Sir Edwin Lutyens. It was inaugurated in 1927. The Indian Constitution does not explicitly mention parliamentary committees. However, Article 118 of the Constitution gives Parliament the power to make rules for its own procedure and conduct of business. This includes the power to set up committees. Parliamentary committees are an important part of the Indian parliamentary system. They help Parliament to scrutinize the work of the government, to oversee the implementation of laws, and to make recommendations for improvements. There are two main types of parliamentary committees in India. Standing committees. These are permanent committees that are set up to examine a particular area of government work. There are 24 department-related standing committees, DRSCs, in the Lok Sabha and 22 in the Rajya Sabha. Each DRSC is responsible for examining the work of a particular ministry or department. Ad hoc committees. These are temporary committees that are set up to investigate a specific issue or problem. Ad hoc committees are usually appointed to study a bill before it is introduced in Parliament, or to inquire into a matter of public importance. The members of parliamentary committees are elected or nominated by the members of Parliament. The chairman of a committee is usually a senior member of the ruling party. Parliamentary committees play an important role in the Indian parliamentary system. They help to ensure that the government is accountable to Parliament and to the people. They also help to improve the quality of legislation and to ensure that it is implemented effectively. Here are some of the functions of parliamentary committees. Scrutinize the work of the government, including the budget, legislation, and administration. Examine the implementation of laws and policies. Make recommendations for improvements. Investigate allegations of corruption and maladministration. Serve as a forum for dialogue between Parliament and the government. Parliamentary committees are an essential part of the Indian parliamentary system. They help to make Parliament more effective and to ensure that the government is accountable to the people. Here are some important parliamentary terminologies in the Indian Constitution. Bill. A bill is a proposed law that is introduced in Parliament. Bills can be introduced by the government or by private members. Motion. A motion is a proposal that is made in Parliament for its consideration. Motions can be of different types, such as a motion for leave to introduce a bill, a motion for adjournment of the House, or a motion of no confidence. Resolution. A resolution is a formal expression of opinion by Parliament. Resolutions can be passed on a variety of matters, such as the conduct of the government, the state of the economy, or international relations. Debate. A debate is a discussion of a bill, motion, or resolution in Parliament. Debates are usually held in the Lok Sabha and the Rajya Sabha. Voting. Voting is the process of making a decision by counting the votes of the members of Parliament. Voting can be done by voice vote, division vote, or electronic voting. Quorum. A quorum is the minimum number of members of Parliament who must be present in the House for a meeting to be valid. The quorum for the Lok Sabha is 100 members and the quorum for the Rajya Sabha is 55 members. Speaker. The Speaker is the presiding officer of the Lok Sabha. The Speaker is elected by the members of the Lok Sabha and is responsible for maintaining order in the House. Chairman. The Chairman is the presiding officer of the Rajya Sabha. The Chairman is elected by the members of the Rajya Sabha and is responsible for maintaining order in the House. Question hour. Question hour is a period of time in Parliament when members can ask questions to the ministers. Question hour is held every day in the Lok Sabha and the Rajya Sabha. 0 hour. 0 hour is a period of time in Parliament when members can raise matters of urgent public importance. 0 hour is held immediately after question hour. Budget session. The budget session is the session of Parliament in which the government presents its budget. The budget session is usually held in February or March. Monsoon session. The monsoon session is the session of Parliament in which the government presents its legislative agenda for the year. The monsoon session is usually held in July or August. Winter session. The winter session is the session of Parliament in which the government presents its annual report. The winter session is usually held in November or December. These are just some of the important parliamentary terminologies in the Indian Constitution. There are many other terms that are used in the context of parliamentary procedures and practices. Sure, here are some other important parliamentary terminologies in the Indian Constitution. Adjournment motion. A motion that is moved to adjourn the House for a specified period of time. Adjournment motions can be moved for various reasons, such as to discuss a matter of urgent public importance or to protest against the government's policies. Calling attention motion. A motion that is moved to draw the attention of the House to a matter of public importance. Calling attention motions are usually used to raise matters that are not urgent enough to warrant a debate or a no-confidence motion. Cut motion. A motion that is moved to reduce the amount of money allocated for a particular item in the budget. Cut motions are usually moved by opposition members to protest against the government's spending priorities. Dissentient minute. A minute that is recorded by a member of Parliament who disagrees with the decision of the House. Dissentient minutes are usually recorded to express the member's views on a particular issue. Dissolution of Parliament. The process by which Parliament is dissolved by the President. Dissolution of Parliament can happen automatically after the expiry of its term of 5 years, or it can be done by the President at his discretion. Enacting formula. The section of a bill that establishes the whole document as a law. The enacting formula is usually found at the beginning of a bill. Estimates. The financial statements that are presented to Parliament by the government every year. The estimates include the government's revenue and expenditure for the coming year. Finance bill. A bill that is introduced in Parliament every year to authorize the government to raise taxes and spend money. The finance bill is usually introduced in the budget session. Legislative Council. A second chamber of a legislature. The Indian Constitution does not provide for a legislative council in the Union Parliament. However, some states have legislative councils. Money bill. A bill that deals with the raising of revenue or the expenditure of money. Money bills can only be introduced in Parliament by the government. No confidence motion. A motion that is moved to express the lack of confidence in the government. A no confidence motion can be moved by any member of parliament. If the no confidence motion is passed, the government must resign. Ordinary bill, a bill that is not a money bill or a constitutional amendment bill. Ordinary bills can be introduced by the government or by private members. Parliamentary secretary, a member of parliament who is appointed by the prime minister to assist a minister. Parliamentary secretaries do not have any voting rights in parliament. Question hour, a period of time in parliament when members can ask questions to the ministers. Question hour is held every day in the Lok Sabha and the Rajya Sabha. Session of Parliament, the period of time during which Parliament is in session. Parliament usually has 3 sessions every year: the budget session, the monsoon session, and the winter session. Standing Committee, a permanent committee of Parliament that is set up to examine a particular area of government work. There are 24 department-related standing committees, DRSCs, in the Lok Sabha and 22 in the Rajya Sabha. Whip, a member of parliament who is appointed by a political party to ensure the attendance of party members in parliament and to secure their votes on important issues. These are just some of the other important parliamentary terminologies in the Indian Constitution. There are many other terms that are used in the context of parliamentary procedures and practices. Sure. Here are some other important parliamentary terminologies in the Indian Constitution. Adjournment, the temporary suspension of a meeting of Parliament. Adjournments can be moved by the Speaker or by a member of Parliament. Allocation of business, the process by which the Speaker decides which bills and motions will be taken up for discussion in Parliament. Censure motion, a motion that is moved to express disapproval of the government's conduct. Censure motions are usually moved by opposition members. Closure motion, a motion that is moved to end debate on a particular bill or motion. Closure motions can only be moved by the government. Constitutional Amendment Bill, a bill that seeks to amend the Constitution of India. Constitutional amendment bills can only be introduced by the government. Discharge motion, a motion that is moved to express disapproval of the way in which a minister has discharged his or her duties. Discharge motions are usually moved by opposition members. Engrossed bill, a bill that has been passed by both houses of parliament and is ready to be presented to the president for his assent. Financial resolution, a resolution that is passed by parliament to authorize the government to raise money or spend money. Financial resolutions are usually passed in connection with the finance bill. Government business, bills and motions that are introduced by the government. Government business takes precedence over all other business in parliament. Joint sitting, a meeting of both houses of parliament that is held when the two houses are unable to agree on a bill or motion. Legislative Council, the upper house of a bicameral legislature. The Indian Constitution does not provide for a legislative council in the Union Parliament. However, some states have legislative councils. Ordinary bill, a bill that is not a money bill or a constitutional amendment bill. Ordinary bills can be introduced by the government or by private members. Parliamentary debate, a discussion of a bill, motion, or resolution in Parliament. Parliamentary debates are usually held in the Lok Sabha and the Rajya Sabha. Parliamentary privileges, the rights and immunities that are enjoyed by members of Parliament. Parliamentary privileges are intended to protect members of Parliament from interference in their work. Private Member's Bill, a bill that is introduced by a member of Parliament who is not a minister. Private members' bills are rarely passed by Parliament. Question: a request for information or clarification that is addressed to a minister by a member of Parliament. Questions are usually asked during question hour. Sessional paper, a document that is presented to Parliament by the government to provide information on a particular matter. Sessional papers are usually presented in connection with a bill or motion that is being considered by Parliament. Standing order, a rule that governs the procedure of Parliament. Standing orders are made by Parliament itself and cannot be changed by the government. Subordinate legislation, rules and regulations that are made by the government to implement laws that have been passed by Parliament. Subordinate legislation is also known as delegated legislation. I hope this helps. Let me know if you have any other questions. The judicial system of India is a single integrated system. It is a pyramidal structure with the Supreme Court of India at the top. High courts are below the Supreme Court, and below them are the district and subordinate courts. The lower courts function under the direct superintendence of the higher courts. The Supreme Court is the highest court in India. It has original jurisdiction in a few matters, such as disputes between states or between the central government and a state. It also has appellate jurisdiction over the decisions of the high courts. The Supreme Court can also issue writs, such as habeas corpus and mandamus, to protect the fundamental rights of the citizens. The high courts are the highest courts in the states. They have original jurisdiction in a wide range of matters, such as civil and criminal cases. They also have appellate jurisdiction over the decisions of the lower courts. The district courts are the first level of courts in the hierarchy. They have original jurisdiction in most civil and criminal cases. The subordinate courts are the lowest level of courts in the hierarchy. They have original jurisdiction in petty civil and criminal cases. The judicial system in India is based on the common law system. This means that the judges are bound by precedent, which is the decision of a higher court in a similar case. The judicial system in India is independent of the executive and the legislature. This means that the judges are not subject to the control of the government. The judicial system in India is responsible for interpreting the law and settling disputes. It also plays an important role in protecting the fundamental rights of the citizens. Here are some of the important features of the judicial system of India. Single integrated system. The judicial system in India is a single integrated system. This means that all the courts in India are part of a single system and are subject to the same rules and procedures. Judicial independence. The judicial system in India is independent of the executive and the legislature. This means that the judges are not subject to the control of the government. Rule of law. The judicial system in India is based on the rule of law. This means that everyone is equal before the law and that no one is above the law. Fundamental rights. The judicial system in India is responsible for protecting the fundamental rights of the citizens. These rights are guaranteed by the Constitution of India. The judicial system in India is facing some challenges, such as a backlog of cases, corruption, and lack of resources. However, the judiciary is committed to providing justice to the citizens of India. Sure, here is some information about the Supreme Court of India. The Supreme Court of India is the highest court in India. It is located in New Delhi. The Supreme Court has original jurisdiction in a few matters, such as disputes between states or between the central government and a state. It also has appellate jurisdiction over the decisions of the high courts. The Supreme Court can also issue writs, such as habeas corpus and mandamus, to protect the fundamental rights of the citizens. Image of Supreme Court of India, New Delhi. The Supreme Court is composed of the Chief Justice of India and 32 other judges. The judges are appointed by the President of India in consultation with the Chief Justice of India. The judges hold office until they reach the age of 65 years. The Supreme Court is divided into two benches, the original jurisdiction bench and the appellate jurisdiction bench. The original jurisdiction bench hears cases that are filed directly in the Supreme Court. The appellate jurisdiction bench hears cases that are appealed from the high courts. The Supreme Court plays an important role in the Indian judicial system. It is the final arbiter of the law and it protects the fundamental rights of the citizens. The Supreme Court has also played a significant role in shaping the development of the Indian Constitution. Here are some of the important cases decided by the Supreme Court of India. Kesavananda Bharati vs. State of Kerala. This case was decided in 1973 and it established the doctrine of basic structure. The doctrine of basic structure holds that the essential features of the constitution cannot be amended. Image of Kesavananda Bharati vs. State of Kerala case. Maneka Gandhi vs. Union of India. This case was decided in 1978 and it established the right to life and personal liberty as a fundamental right. Image of Maneka Gandhi vs. Union of India case. Romesh Thapar vs. State of Madras. This case was decided in 1950 and it established the freedom of speech and expression as a fundamental right. Image of Romesh Thapar vs. State of Madras case. Indira Gandhi versus Raj Narain. This case was decided in 1975 and it held that the Prime Minister of India is not immune from prosecution. Image of Indira Gandhi versus Raj Narain case. Navtej Singh Johar versus Union of India. This case was decided in 2018 and it decriminalized homosexuality in India. Image of Navtej Singh Johar versus Union of India case. The Supreme Court is a vital part of the Indian democracy. It is the guardian of the Constitution and it protects the fundamental rights of the citizens. The Supreme Court has played a significant role in the development of India and it will continue to do so in the years to come. There are 4 other types of courts in India. Aside from the Supreme Court, High Courts, there are 25 High Courts in India. Each High Court is located in the capital of a state or union territory. The High Courts have original jurisdiction in a wide range of matters, such as civil and criminal cases. They also have appellate jurisdiction over the decisions of the district and subordinate courts. Image of High Courts in India. District Courts. There are about 200 district courts in India. Each district court is headed by a district judge. The district courts have original jurisdiction in most civil and criminal cases. Image of district courts in India. Subordinate courts. There are about 5,000 subordinate courts in India. These courts are headed by magistrates and judges. The subordinate courts have original jurisdiction in petty civil and criminal cases. Image of subordinate courts in India. Special courts. There are also a number of special courts in India, such as the Central Administrative Tribunal, the Armed Forces Tribunal, and the National Green Tribunal. These courts have jurisdiction over specific matters, such as administrative disputes, military law, and environmental law. Image of special courts in India. The High Courts and the District Courts are the main trial courts in India. The subordinate courts hear petty cases and cases that are appealed from lower courts. The special courts hear cases that are related to specific areas of law. The judges of the High Courts and the District Courts are appointed by the President of India in consultation with the Chief Justice of India. The judges of the subordinate courts are appointed by the state governments. The judicial system in India is facing some challenges, such as a backlog of cases, corruption, and lack of resources. However, the judiciary is committed to providing justice to the citizens of India. Judicial review is the power of the courts to declare laws or government actions to be unconstitutional. It is a fundamental principle of the rule of law, which is the principle that everyone is subject to the law, including the government. Judicial activism is a term used to describe the practice of judges interpreting the law in a way that expands the rights of individuals or groups, or that restricts the powers of the government. Judicial activism is often contrasted with judicial restraint, which is the practice of judges interpreting the law in a way that is consistent with the intent of the legislature. Judicial review and judicial activism are both controversial concepts. Supporters of judicial review argue that it is necessary to protect the rights of individuals and to ensure that the government does not overstep its bounds. Opponents of judicial review argue that it gives too much power to the courts and that it can lead to judges making decisions that are not based on the law. Supporters of judicial activism argue that it is necessary to ensure that the rights of individuals are protected, even when the government is trying to restrict them. Opponents of judicial activism argue that it can lead to judges making decisions that are based on their own personal beliefs, rather than on the law. The Supreme Court of India has played a significant role in both judicial review and judicial activism. In the case of Kesavananda Bharati vs. State of Kerala, 1973, the Supreme Court established the doctrine of basic structure, which holds that the essential features of the Constitution cannot be amended. This decision has been used by the Supreme Court to strike down laws that it has found to be unconstitutional. In the case of Maneka Gandhi vs. Union of India, 1978, the Supreme Court held that the right to life and personal liberty is a fundamental right and that it cannot be curtailed except in accordance with the law. This decision has been used by the Supreme Court to strike down laws that it has found to be unconstitutional. The Supreme Court has also played a role in judicial activism. In the case of Navtej Singh Johar vs. Union of India, 2018, the Supreme Court decriminalized homosexuality in India. This decision was controversial, but it was seen by many as a victory for judicial activism. The debate over judicial review and judicial activism is likely to continue for many years to come. There are strong arguments on both sides of the issue, and it is a complex issue with no easy answers.